All right. Thank you so much, everyone, for joining us today for our webinar on what to expect in 2024, current and anticipated trends in Afghan asylum cases. We're very happy to have all of you here with us today, and thank you for taking the time out of your day to join us. My name is Stephanie Baez, and I'm the Director of Pro Bono with the American Bar Association Commission on Immigration, and I'm going to be facilitating the event today, and I'll introduce our panelists in just a moment. But before I do, I want to jump into some housekeeping things to keep in mind throughout today's webinar. The first thing to remember is that we are recording this webinar and it will be available for future viewing. You'll be able to access the webinar on the ILSAA Peer Networking Hub. We'll also be sending out an email that has the slides from today's webinar, so you will be able to access these materials even after today. Today's webinar is an interactive experience and we'll have plenty of time for questions and answers throughout. Please be mindful to keep your mute button on so that we can hear the panelists. And if anyone has issues with the mute button, we can come through and we'll try to help with that. And if there's something that you want to say, please raise your hand on the Zoom. Otherwise, please use your participant chat box. You're really encouraged to use that throughout the webinar to share any questions or comments that you might have as we're going through. I'll be monitoring the chat box during the presentation, and we're going to reserve time for Q&A at the end. But also, if there's some relevant questions that come up during certain slides we're talking about, then I'll try to flag those for the panelists while we're on that topic. So please share questions in the chat box. And please keep in mind that when you're asking questions today, we can't really answer case-specific questions. So if you have questions about a specific situation or a specific client, this webinar is not the appropriate forum for that. But at the end of the webinar, we'll share some resources and opportunities for office hours with some of our panelists where you could get those questions answered. If you have any technical issues during the webinar, please send a private message to Hannah, and her information is, you should have received it in the Zoom invite that you received, and she'll do her best to assist you. And then also an evaluation link and a copy of this slide deck will be sent out after the webinar. And we'll ask for you to complete that evaluation so we can have some feedback on today's webinar. Our agenda for today, I'm going to do some welcomes and introductions, and then our panelists will jump into statistics, current trends and issues, then anticipated trends and issues, some information about asylee adjustment of status, specifics on tips and tricks when working with USCIS, and then time for Q&A at the end. So it's now my pleasure to introduce our two panelists. First, we are joined by Aminat Sabak, who's the network support attorney for Pro Bono and Partnerships with HIAS. And Aminat helps run several of the Pro Bono and Partnership team national projects, including providing legal services to Afghan clients of HIAS refugee resettlement affiliates and Afghans in Maryland, also providing remote support to Venezuelans, Haitians, Cameroonians, Afghans, and Ukrainians seeking TPS. She develops trainings and other resources to support HIAS affiliates and HIAS staff and volunteer attorneys who are involved in HIAS pro bono work. So thank you so much, Aminat, for being here and sharing your expertise with us today. And we're also joined by Jenny Guilfoyle, the legal director at Vicina. At Vicina, Jenny oversees all of the training and mentorship on immigration cases, including asylum, adjustment, and family reunification for Afghan evacuees. Jenny has more than 20 years of experience working in the immigration nonprofit sector, and much of that time has been spent as a trainer and mentor. So also thank you to you, Jenny, for being here and sharing your expertise with us. And with that, I'm going to turn it over to Aminat to get us started.
Thank you so much for the lovely introductions. And I want to jump into the statistics and talk about Afghan asylums and how this has been going for everyone. So you see a little chart on the left, and that information, that data has been provided by USCIS as part of the settlement on the OAW asylum adjudications, where the government promises to give us data on asylum adjudications for Afghans every 30 days. So the data that you have here is the total number of asylum applications that has been received for Afghans, OAW Afghans, which is 20,122. And you can see that 12,479 applications have already been adjudicated. And out of that, 12,122 cases have been granted. We also see that there are some denials, very little number, 26 cases have been denied, 331 cases have been admin closed, and 7,643 are still pending. We also know that around 75 cases have received notices of intent to deny, but I think overall cases are being adjudicated actively. We're seeing a very high rate of approvals, which is a really positive development. So we're really excited to see these approvals trickle in after the settlement, which I think we're going to talk a bit more about later. So I think really positive statistics. And let's go into the trends now. Thank you. So we broke up the trends into a couple of buckets. First bucket that I want to touch upon, filing trends and things that we have been seeing regarding filing of asylum applications. If you do this a lot, if you work on asylum cases a lot, you might have noticed that the addition date of the 589 form has changed. So make sure that you use a new addition date if you're filing an asylum case. The new addition date is March 1st, 2023. If you use an old form, it will be rejected by USCIS. Couple of things to know about the new form. It became easier to file for clients that have a big family, that have dependents. You do not need to duplicate the whole packet for each derivative. You file one packet, you include proof of relationship, and that should be sufficient. You do not have to copy the 589 times and times for each family member. You do not need to attach a picture anymore, which basically mirrors the online application where you do not need to submit a picture. So you basically send in the 589 without a picture now. Also note that the mailing address has changed for the 589. Make sure that you always check the mailing instructions when sending things through mail. Another thing that has come up a lot for Afghans, mistakes on I-94 and requesting changes. So USCIS has provided us with an email for I-94 changes. They also now direct you to the CBP website to make I-94 changes. But this website listed, or this email rather, listed on the slide has been most helpful and efficient for our team and also for volunteer attorneys that we've been working with on Afghan cases. The changes are done pretty fast and efficiently when you send a request to that email address with underlying identity documents that prove correct spelling or prove correct date of birth that you want to be reflected on the I-94. One thing that I noticed with the I-94 changes is that sometimes you're not going to receive confirmation from this email saying, yes, we made the change. You can proactively go onto the I-94 page of the CBP website and check your client's I-94 with the correct spelling that you requested or correct date of birth that you requested. And typically within several days or a week or so, it should come up corrected. So make sure you go in and check your I-94 after you have requested the correction. We have heard reports of people getting issues with filing applications online. Some applications have been getting rejected in the system. Hopefully that's a glitch, that's a temporary issue and should be corrected soon. But we have been seeing some issues with online filings recently. In another news, the expedited processing and the fee exemptions have been extended as of end of September of 2023 for Afghans. So the fees that Afghans did not have to pay in the past, they still do not have to pay those fees for the same applications. And expedited processing that was available for the forms in the last couple of years are extended. So they're still processed expeditiously by USCIS. So all that has been extended. We were worried in the community that expeditious processing and the exemptions were running out. And it was, we were worried that they're not going to be expeditiously processed anymore. But fortunately, the processing has been extended through end of September of 2024. And let's look at the next slide and our post-filing trends. So what are the things that we have been seeing after the 589s are filed? We, again, as I mentioned before, we have seen attorneys and clients experiencing a delay in getting notifications on cases filed online most of the time. We have seen that some of those notices, requests for evidence, are posted on the USCIS account of the attorney or the client and not mailed, or mailed late and not always timely for people to be able to respond to those requests timely. So if you have filed your case online, please make sure that you check the USCIS account to see any notices that come through that account. Another issue that we have seen post-filing is double derivative issues when both principal applicants, typically it's in a couple situation when both applicants are married and they file both as principal applicants, but they also list each other as derivatives. We have seen USCIS Asylum Office ask one of the applicants to withdraw their asylum case to be able to expeditiously process the application. It seems that asylum offices want to adjudicate both cases at the same time, meaning they want both clients to be interviewed at the same time. And if for some reason second person has not been interviewed on the same date, they ask that second person to withdraw to be able to process that one case for the principal and give a decision on that specific case. So that's a thing that we've been seeing post-filing. Let's look at our trends, interview trends. So this is, again, an old new policy, meaning that this policy has changed during COVID, but now we're back at it where you're required to bring interpreters to the interviews. As you may know, you didn't have to bring them until I think September of 2023, but you have to start bringing your interpreters to the interviews. And USCIS does provide a monitor. They do not provide an interpreter, and monitor is there to make sure that interpretation is done correctly. They will not provide an interpretation. So clients have to bring their own interpreters. We have also heard that there's a new policy, which I don't think has been written out anywhere. It's an internal USCIS guidance issued to asylum officers regarding Afghan women being considered a cognizable PSG without having to establish or without past persecution. So again, there's not really a publication or reference available, just seems like an internal guidance that has been issued to the asylum officers. Another trend that we have been seeing with interviews is continued one-year filing deadline questioning, which Afghan clients who entered on parole, who have been re-paroled, should be exempt from. However, asylum officers have to go through their script and have to ask one-year deadline questions if somebody is filing after the 1 year. So just to know, to make sure you prepare your clients to answer those questions, because I think some of us, especially initially, we're going into interviews knowing my client is exempt, they should be fine. And then clients are really thrown off by those 1 year deadline questions if you don't warn them ahead of time that this will come up. And also another thing to keep in mind is that now that parole ran out and many people have been re-paroled, there's still some clients whose re-parole is still pending, or some clients they may have not filed for re-parole. And those are the clients that you really need to make sure or check on the 1 year deadline for. So just a note to check on those parole statuses and think about the 1 year when you're filing asylum for Afghans.
And can I just jump in here? I mean, that someone asked in the chat if you could just repeat the point that you made about the female applicants, just to be sure that they understood what you were saying. So if you could just reiterate that point.
Totally. So there is an internal USCIS guidance that has been issued to asylum offices regarding Afghan women being a cognizable PSG without past persecution. So it seems that asylum officers recognize that women from Afghanistan are a particular social group. They are cognizable, and even if there has never been past persecution, that's solid basis for asylum. They can also claim political opinion, being opposed to the Taliban norms, feminist political opinion. So those are very strong claims. I hope that answers the question.
Thank you.
Sure. I think we can go to the next slide.
Great. And I think, thanks.
Oh, yeah. And I'm passing it on to Jenny here. Thank you.
Thank you so much. I actually wanted to the previous slide made me think of something that I just wanted to flag for everyone about interpreters. And I know there have been questions too about like, wait, why is everyone required to bring an interpreter now? What's going on? And just to reiterate what Amanat said, that this, for years and years, this has always been the policy at the asylum office. You always had to bring your own interpreter. They only changed that under COVID. So if you're someone who's new to this practice and has only been doing this for a few years, it seems like this weird change. But in fact, they're just going back to their previous, admittedly frustrating practice of saying that every asylum applicant has to bring their own interpreter. But I also just wanted to bring everyone's attention to who can be an interpreter at asylum interviews, because I know that comes up sometimes as a question. And I believe that it's actually posted on uscis.gov somewhere on one of their pages that they will accept as an interpreter. For a while, they were saying that if you had an Afghan who had applied for asylum themselves couldn't be an interpreter. Now they're saying if you're an Afghan asylum applicant and you've already been interviewed, you can be an interpreter. The exception is if somebody is a witness on that case. So you can actually bring your family member to interpret as long as they're not a witness on the case or a derivative on the case, and they've already had an asylum interview. So just wanted to bring everyone's attention to that. I know we've had pro bono teams show up at the asylum office and have the people at the front desk tell them like, no, she's your sister, she can't interpret. Well, that's not correct. A sibling can be the interpreter, again, as long as they're not a derivative or a witness on the case. And so it can be helpful sometimes to print those things out and bring them along to the asylum office to show them if the folks at the front desk seem to be unaware of what USCIS's own posted rules are.
And a quick follow-up question on that, Jenny. Someone just asked if the interpreter can be one of the translators.
Yeah.
Did the documents and evidence for the application.
For sure. Yeah, and I think that's actually pretty common. Yeah, no problem at all. Again, as long as they otherwise meet the rules for who can be an interpreter at the asylum office. Yes, that wouldn't be a problem at all. And okay, so then turning to what's actually on this slide, I wanted to talk a little bit what's happening with family reunification.
I would like to highlight, yeah.
What if whoever that is can just those on mute? Somebody is not me. Thank you. So family reunification, there's two different avenues open for, whoops.
Just advance my
They are on mute.
thank you that.
Two avenues for family reunification. And one of them, I think that probably most of you on the call are aware of these two things. And one is the State Department form DS 4317 that they launched online, I think it was last year. And that is a way for people who were paroled into the United States to request that the U.S. relocate their spouse and minor children to the United States by actually putting them on planes, bringing them from Afghanistan or some other country, bringing them somewhere else outside the United States for processing, and then bringing them to the United States. And this is something we wanted to highlight for a few reasons. First of all, like who's eligible to fill this out? If you go to the State Department website, you'll see that they are aiming this particular category, the DS 4317, at OAR parolees. So not someone who's already been granted asylum, but someone who's a parolee can fill this form out and request reunification for their spouse and their children. And they define that as your spouse and children as of August 14th, 2021. And they say your children have to currently be unmarried and have to have been under 21 as of August 14th, 2021, when the evacuation began. And that's also listed there on the DS 4317. So a child who has since turned 21, as long as they continue to be unmarried, would still be eligible for this reunification. We know that there's been a fair amount of confusion in the community about who's eligible for this reunification, with people thinking that maybe somehow they're
parents or their siblings, that they be able to ask for reunification through this portal for their parents and siblings, and that's not true. I think that maybe the confusion arose because the State Department, in an effort to be complete, also expressed that like U.S. citizens can petition for their parents and siblings, which is true, but a parolee is obviously not the same thing as a U.S. citizen, and that parolee, it's going to take years and years before they become a U.S. citizen and are eligible to file through the family-based immigration channels. So this family reunification portal is really just for that narrow population of the spouses and children of parolees. Also, all of this is coordinated. Again, many of you probably know this through a new office at the State Department called CARE, which stands for Coordinator for Afghan Relocation Efforts, I think. I think that's what it stands for. And they are coordinating all of this. And the way it works is that they will reach out to, once a parolee submits the required information in the form, which is very, very simple, they will eventually start reaching out at some point to those family members with requests sometimes for more information, more documents. One of the things that's really important to stress with clients up front when they're submitting one of these 4317s is that every beneficiary is going to need a passport in order to travel to the U.S. through this relocation process, no matter how young the child is. And because it can take a long time and be difficult to get a passport in Afghanistan, it's good to let people know that up front so that they can get started on this. There's no clear answer for how long this care process might take, and there's no guarantee that any particular individual is going to be relocated this way. Unfortunately, we just we don't know, but it's certainly worth submitting people's information and asking about it. And again, everyone's going to need a passport. That's not a requirement of the United States. It's a requirement of the other countries to which people are traveling before they come to the United States. And my understanding at this point, although folks in the chat who've had experience with this, please weigh in, is that for many people that CARE is relocating this way, what they're going to be doing now is doing kind of expedited refugee interviews with people, with the idea of bringing them into the United States in refugee status. So far, there have not been a lot of people that have gone through this process. If anybody in the chat has had anyone actually make it all the way through this process, please jump in and share that. That's really helpful. There's also, and Henry just helpfully pointed out in the chat, that there's now a way to do an online status inquiry with the State Department about the 4317. And I think it instructs you that if you've submitted one of these and you haven't yet heard back from the CARE team, you can submit a status inquiry, because for a while there was no way to inquire really, or there was just the CARE team email inbox and they were overrun and didn't have the opportunity to respond to everyone.
So Jenny, just quickly, while we're on this slide, there is a discussion in the chat about proxy marriages and whether proxy marriages are valid for the filing of the DS 4317 for parolees. And the chat discussion is centering around, understanding that proxy marriages are not recognized for an immigration application unless the couple later consummates the relationship and meets in person. But I just, if there's anything else to add on that issue.
It's a great question. I think it's a question that should continue to be put to the CARE team. I mean, I don't think there's anything to stop you from trying. Like, I wouldn't not submit a 4317, but you would need to kind of explain the circumstances here, because they are going to be doing refugee interviews with people. So it's separate from the I-730, which does depend on the existence of an already existing legal marriage. The 4317 is an avenue to get people on a plane to a third country where they're going to probably undergo a refugee interview and have to prove their own independent refugee claim. So I haven't seen anything from the CARE team or heard anything saying that they would recognize that and would put them on a plane. But again, unless someone thinks differently, I don't see a harm in trying. And I think it's definitely a worthwhile, useful question to be putting to the care team in, further stakeholder engagements with the care team, because it's an important question. So thank you for asking that. The I-730, of course, is the family reunification process for people granted asylum or for people granted refugee status. So once someone has been granted asylum in the United States, they're supposed to now be filing the I-730. And that's people granted asylum or refugee status have 2 years after admission as a refugee or grant of asylum to file the I-730 for their lawful spouse and minor children who are outside the United States to enter the U.S. As derivative asylees or refugees. USCIS, as with all Afghan applications, says that they're prioritizing adjudication of Afghan I-730s. I know that I've seen a lot of advocates reporting that generally these are taking about 3 to 5 months for USCIS to do their piece of the I-730, which is the initial adjudication of the form. There's ongoing questions about which consulate to list, because you have to list a consulate on the form as to where the beneficiaries, the spouse and minor children, are going to consular process. Obviously, there's a lot of beneficiaries in Afghanistan, and obviously, there's no consular processing in Afghanistan. And so people are kind of still figuring out what the best way to do this is. Some folks have beneficiaries who are able to travel to another country where they're able to consular process. And so that's certainly an option. And I believe that all consular posts around the world have been instructed that they're supposed to be accepting these for processing. But it can be really difficult, though, for beneficiaries to be able to get to another country, to even be allowed in with it, whether you need a visa or not. There are some countries that allow people in without visas, or where it's easy to get a visa, and then people have to live there and support themselves while waiting for an interview. So this is kind of like an ongoing piece to figure out. The other kind of puzzle piece here, and it's kind of like the puzzle doesn't all quite exactly fit perfectly together yet. Like, we're all working together to figure this out. And the government is still shuffling around, as I understand, to figure this out, because the care team relocation is also supposedly now available to people with approved I-730s, so that, in theory at least, beneficiaries with approved I-730s who are in Afghanistan may be eligible now for care team relocation to a third country, where instead of undergoing their own full refugee interview, they would undergo I-730 consular processing. And so there may be a benefit to listing Kabul, but again, there's no guarantee. So I wish I'd had a magic answer for everyone on this. This is definitely a place where all of us need to kind of keep in touch with each other to figure out moving forward what the best way forward is. And also, obviously, the circumstances of every particular family's circumstances are different in terms of what they want to try to do. You certainly can, you have to list a consulate on the I-730. That can be changed at the point where the case moves from USCIS to the State Department, and the National Visa Center then sends the case out to a consulate for processing. So you can, what goes on the form in the beginning does not have to be the end result about where the case goes. And so I can see there's tons of chat here, which is amazing. And folks that also have had experiences with doing this and thoughts about it, please weigh in there. Because again, this is a place where there aren't super clear answers right now to all of these important questions.
Jenny,
Yes.
I'd like to also mention unaccompanied minors, because in case anybody is working with unaccompanied minors, generally CARE starts cases or started cases for them to reunify with their parents and siblings, I think. And if you have not heard that your clients have been working with the care team, you can try to inquire about whether there is a case or not. And if you're not able to figure this out at all, and your clients have not been in touch with anybody, they can use that DS 4317 form as well. I think that has been recently updated to include parents of unaccompanied minors and siblings as well.
Yeah, thank you so much for that really important point, Aminat. We've actually at Basina had a few teams working with unaccompanied minors whose parents actually were brought here to the United States through the care team. So it definitely has happened and can work, which is really, really, really exciting. So let's move on to the next slide, anticipated trends and issues. So Aminat mentioned earlier, and she shared statistics that was based on the processing times, the class action lawsuit that was brought against USCIS for failure to meet the congressionally mandated deadline of adjudicating OAR parolees' asylum applications within 150 days of submitting the applications, because that's the statutory mandate that Congress gave to USCIS that they were completely failing to do for the first year or so of adjudicating the cases. And this class action was settled last year. The case, it's called Ahmed, and USCIS has now sped up adjudication. So I know lots of folks have seen a lot of adjudications, almost all of them approvals, and they're going to continue doing that. The adjudications continue. Those statistics that Aminat shared earlier are available on USCIS.gov. Part of the settlement is that they continue to provide these publicly available updates on the progress that they're making towards the settlement agreement. And if you just look up Ahmed settlement on USCIS.gov, you can find those. Some of the upcoming deadlines that they have is that, as of this point, an upcoming deadline is that they will, by April 30th of this year, they have to have adjudicated 90% of OAR parolee asylum applications that were filed on or before December 2nd of 2023. After that, by June 30th, they have to adjudicate 90% of the cases that were filed by February 1st, 2024. And basically, from here on out, they need to be adjudicating 90% of OAR parolee asylum applications within 150 days of filing. And they get that extra 10% wiggle room because the statute does allow for extraordinary circumstances. But so we should all be seeing adjudications happening much more quickly. I do want to note that some people still have cases that have been pending a long time. And I know I've talked with or heard from the class counsel for this class action settlement, and they certainly feel that, people with cases that are pending for a long time still can file individual mandamus actions, even though they may be part of the class in the class settlement, that people still can file individual mandamus actions to try to get a decision on their long pending case that hasn't been decided yet. I know at Facina, we've had a few teams get up to the point of actually filing a mandamus in federal court, which then resulted in the client getting an approval and USCIS handling the case. So that's obviously a huge amount of work. And if anybody is interested in learning more about that and having some sample materials, I'd be very happy to share that, and you can reach out to me. I'm just putting my email in the chat. Feel free to reach out. But we do anticipate a much faster pace of adjudications, so that is exciting. On our next slide, just some other tips on working with USCIS. We've put a link to some ways to contact USCIS, but I also just wanted to give kind of a shout out to familiarizing yourself, if you're doing asylum cases, with USCIS's own internal guidance for asylum officers. It's really, really, really helpful to look at those. I strongly recommend doing that. There's something called the Affirmative Asylum Procedures Manual that talks all about, it's like 150 pages of detailed procedures about how asylum interviews go, how a case kind of moves through the asylum office. I would also strongly recommend looking at the RAO. It stands for Refugee Asylum International Operations. That's the part of USCIS that oversees the asylum office. They have training plans for their asylum officers that tell them everything about how USCIS wants them to adjudicate cases. And I think it's really, really helpful to familiarize yourself with those. And to kind of like make that your first stop when you're thinking about how to frame your case, and also just how the asylum office should be conducting cases. Where can you find these? So you can Google them. Just Google Affirmative Asylum Procedures Manual. You can actually Google the RAO training plans. If you're a member of ILSAA, some of you may be, ILSAA also has them. And I will also say that we have Vecina has an online course, a free online course on affirmative asylum for Afghan nationals. And we have a link to it later in the slides. And we have a bunch of the training plans linked to from our course. But literally just Google them. And they're training plans on like every aspect of an asylum case. So that includes both asylum law and also the way that the asylum officer is supposed to conduct the interview, that it's a non-adversarial interview and the way that that's supposed to work. So all of those can be really, really, really helpful because those are literally like their marching orders about how they're supposed to be handling cases. So it's really helpful to have those. And then the USCIS policy manual, which is online on the USCIS website. There's a pull-down menu on the website for laws. And one of the things that you can find links to there is their policy manual. And so we're going to be talking, Aminat will be talking in a second about asylee adjustment of status. There's a whole long section in the USCIS policy manual. And that's really a set of internal guidance for USCIS adjudicators on how USCIS wants their adjudicators to handle cases. So also really, really, really important to be aware of for you. And also sometimes you might encounter an officer who's not perhaps aware of everything that's in the policy manual. It can be a really helpful thing to send them to and to cite to. Remember, and if you're working on an affirmative case, remember that the process is supposed to be non-adversarial, and you can literally find the training plan that tells the officers how they're supposed to conduct asylum interviews in a non-adversarial way. I also wanted to mention something else that's not on here because it's something that Aminat talked about earlier, is online filing. And at Vecina, we really recommend online filing because anyone who's ever filed anything on paper with USCIS knows what can happen in the mailroom there, and it's never anything good. They seem to delight in like pulling your filing apart and throwing the pages all over the floor and losing them and who knows what, and it takes forever to get receipt notices, and they lose things, and then you don't have an exact record of what was filed. Filing online, like once it's there, you get a receipt notice within 24 hours. It's magic. And then you have a clear record of everything that was filed. It's really easy to supplement. So it's a really good idea. But also, again, anyone who's ever worked with USCIS knows that they're perhaps a little bit lacking in the customer service department. And so their website and the online filing system, not the most intuitive. There's some weird quirks. So in the Vecina online course for affirmative asylum, we have a document on tips and tricks for filing online. And if you haven't done it before, strongly recommend doing that. Spare yourself some of the mistakes that I made that caused me to want to throw my laptop out the window. Weird, strange error messages that didn't make sense. But once I figured it out, I was like, oh, okay, that makes sense. So all of those tips and tricks are in there. And if you look at that document and you have a tip or trick that we didn't list, please tell me, because we would love to update our document and incorporate your wisdom. And then finally on here, just some points about what do we mean by making it easy for the asylum officer or the USCIS adjudicator to approve your client's case is I'm thinking about this from the perspective of the adjudicator who, asylum officers, all they do all day long is review asylum cases. Adjudicators reviewing adjustment of status cases, probably they're sitting there all day reviewing these things. How do you make your client's case stand out, but also make it really, really easy for that officer to quickly see what are the important points in your case? And there's a number of different ways to do that, but always kind of keep in mind, generally being concise is really helpful, putting the most important points like on the first page in bold for them, not giving them too much material because then they just won't read it. And thank you to Chelsea for putting the link to the Affirmative Asylum Procedures Manual in the chat. Super helpful. And I'm seeing that there's also a question in the chat. If the asylum officer asks you to make a statement, do you have tips or suggestions? Yeah, definitely. Number one, definitely do it. And you definitely, even if the officer doesn't ask you, most officers will allow you at the end of an asylum interview to make a brief statement on behalf of your client. If you've ever represented someone at an asylum interview, you know that most of the time you're just sitting there taking notes. Unlike being in court, where if you're the attorney for someone or their accredited representative, you have a very active role. the asylum interview, mostly you're just sitting there hopefully taking complete notes of everything that's said. But usually most officers will let you make a brief statement at the end. And so there's not one right or wrong way to do this, but if you notice that something came up in the interview that maybe seemed to be kind of an issue for the officer, you might want to take a few minutes to either make a legal argument about this, draw the officer's attention to evidence that was submitted, to your client's testimony on an important point, to kind of like, if you could tell that there was something that seemed to be an issue, you may want to address that in your closing statement. You also could just take a moment, if things went fairly smoothly, to just kind of summarize for the officer why it is that you think that your client is eligible for asylum. You could also take a moment to ask the officer if there's anything else that they want clarification on. Okay. And Aminat.
Adjustments. I think a lot of questions came in on adjustments. I'm happy to talk through some of our thoughts on adjustment of status. And one of the questions that came up a lot was when to file. And I think the reason is the new policy that USCIS issued in February of 2023 regarding adjustments for asylees and refugees. As you may know, in the past, asylees and refugees could only file for adjustment of status after being in asylum status or refugee status for a year. Now this policy has changed due to USCIS processing times being so long and them taking so long with adjusting people. And now the policy says that asylees and refugees must have been physically present in the United States in their asylee and refugee status for 1 year when 485 is adjudicated, not at the time of filing, but at the time of adjudicating, which means that you could file for adjustment before the 1 year, but at the time of adjudication, they should have the 1 year of presence in asylum or refugee status, which means that as practitioners, we now are wrestling with this strategy. When should we file? We want our clients to get their green cards as soon as possible, but we are also worried that if we file a week too early, that could potentially bring out some errors. It could potentially cause applications being rejected or denied or being granted too early. So these are the risks of filing too early. It may so happen that the 485 application may fall on somebody's desk who does not know about this policy or has not read this policy, and they may improperly deny or reject the application if they see that there has not been 1 year of being an asylee or refugee status. Or another concern that we could see is that if somebody adjudicates this application too early and they grant that green card, they grant that adjustment before the 1 year, then this could potentially come up at this person's naturalization application or naturalization adjudication, that they were not a green card holder at the time of adjudication. They were not eligible to get a green card at the time of adjudication of their 485 application. So those are the concerns that we can see with this new policy. If people are filing way too early, some practitioners have been filing with the policy being printed out, putting it on the top, putting in big bold letters, please hold in abeyance until this X date when the client's 1 year happens. So I think that's a really good strategy to make sure that you put in big bold letters that if you are filing a couple of months before the 1 year anniversary, if you want to try to get your client's case adjudicated faster, make sure that you put those big bold letters, please hold in abeyance until the 1 year anniversary of the client being in asylee status for Afghans specifically, or refugee status if they come on refugee status. So just be careful with this new policy is kind of my thought process here. Another thing that I think comes up a lot is that people are more likely to be fee waiver eligible earlier when they get asylum, right, rather than later on in time. And as you may know, asylees are not exempt. Even Afghan asylees are not exempt from 485 fee requirements. there is an SIV 485 exemption. There's no SILE 485 exemption for a fee. So you would have to file fee waiver. So that's another consideration that you may want to look into it. Okay, my client is getting SNAP for a year, or my client is getting Medicaid for, the next 6 months. I'm going to strategize when I want to file their adjustment application. So those are the things that you may want to think about when you're thinking about the timeline of filing for adjustment for your clients. And I think that's kind of all my thoughts on that timeline. And we can look at the next slide, which is also a question that I saw pop up a lot in the chat about medicals for clients, for paralegals that came in on OAW. And the reason why this question comes up a lot is that because a lot of paralegals that came in on OAW have gotten their medicals done when they were processed overseas. So in theory, and there's a policy on this, that medical examination is valid for 4 years. And in theory, that medical evaluation, if in the file of your client should be used in their adjustment case. Now, that's all in theory. In practice, I don't think we have seen this happen a lot. We have seen some people who have applied for SIV adjustment and who have gotten RFE'd for medicals, which indicates to us that their medical examination has been lost or misplaced or just it's not there. So USCIS is RFEing for it. I don't think we have seen a lot of SILE adjustments yet, right? Because people are just getting approvals now. But I think as we're trying to adjust asylees, we will sort of see what the landscape on this issue looks like. Again, in theory, they should have their medicals in their file. And I think if you want to try to see if it's there or not, you can file without the medical. You can wait for an RFE. You can go to the interview and ask the officer, try to locate the file. It seems that sometimes it's misplaced and could potentially be in the EAD file of your client. So you can try to do some advocacy and reach out to the field office where your client's case is venued and see if they can find the medical file, or you can give up and do the medical. But in theory, again, these people have gotten their medical examinations. And if you're working with a huge family that needs to adjust, needs green cards, it's really costly to do those medicals. And you may want to try filing without the medical and seeing if you will get RFE'd on it and then sort of take it from there. But that's my thought process on medical examinations for adjustment purposes. And Q&A. Thank you.
Great. Well, thank you both so much for all of that information. And as you can see, we've had a really active chat box with a lot of helpful comments and questions, and a lot of people answering each other's questions, which is amazing. So thank you, everyone, for being so active and participating in the chat box. To start, since we were just talking about adjustment of status, I'll just highlight a few comments that were made in the chat box just to make sure that everyone's aware of them. There's a note that USCIS confirmed at the Durham ASC that a denial of a 485 based solely on not having sufficient physical presence is 100% incorrect. So if you're encountering any of these denials, flag them for USCIS and they should be reopened. So just wanted to make sure that everyone saw that comment in the chat. And then there's just some chat about strategy in terms of when to file. And and sorry, Chris, did you want to add anything on that?
Thank you so much, Stephanie. Yeah, just a really quick note. If you don't know where to turn in that situation, you could reach out to your regional coordinator, ILSAA regional coordinator, and we'll be able to kind of quickly contact USCIS on those improper denial notices.
Great. Thank you, Chris. That's really helpful. There's another comment of someone sharing their experience that in their experience, medical exams done on the base after evacuation have not been accepted by USCIS. So just something else to keep in mind in terms of making the decision for with respect to medical exams. That's helpful information about someone's experience. Let's see. Moving away from adjustment of status for a minute, there was a question that came in early that I'll flip back to. that was specifically about EADs and what happens if someone received asylum and they didn't actually get their EAD with that asylum grant. What can they do? Is there someone that they can email, or do they need to submit a I-765 application? What can someone do in that instance?
That's a very good question, actually. And another change that has happened recently, and I have not mentioned in my trends and issues part of the presentation, is that asylee and asylum pending work permits are now coming through for valid for 5 years. Just a quick note that's super helpful for our clients. Now turning to the question on the asylum approved asylee work permit. This came up for my client recently, and it took a little while for him to get his work permit. So he got the approval, and then he had to wait for, I think, even a little more than a month to get his work permit, but eventually it came through. And it seems that they have now started to put a little section on that approval, who to contact at the local asylum office regarding a work permit that didn't come through, in the event that it doesn't come through. At least one of the approvals that I have seen has had that like little paragraph in it. So you may want to look back at the approval and see if that information is there. If not, I would contact USCIS and see if they have any helpful information. And I would also flag it to the local asylum office that has approved your client's case and see if they could also give you a contact or any information about the work permit, but it should be mailed to the client. Maybe it doesn't happen right away, but it should in theory be sent to them after the approval. And I don't know if Jenny, you want to add anything to that, but that's been my experience.
Okay, thank you. That's helpful. Another question that came up is in terms of family reunification. If there's an individual who has been approved, has asylum approval, and then they have a family member who arrived through the southern border, what options does that family member have in terms of having any sort of benefits attributed to them as well?
And what by family member, do we mean somebody who would be, could be a derivative asylee, like a spouse or minor child?
The question said immediate family member, so I'm going to say yes. Let's assume that it's someone that could be a derivative.
Yeah, I mean, you can file an I-730 for someone who's in the United States. That's what I would do. Yeah, however they got here, because the means that you entered the United States is not a bar to asylum. So I would file an I-730 if it's their spouse or minor child, that somebody who would be eligible for an I-730. I would do an I-730.
Fantastic. Thank you. That's helpful. Let's see. There are so many great questions coming in. I'm trying to bunch some so that we get to the topics that everyone's been asking about. Let's see.
And Steph, while you're looking at those, I can just give everyone a preview that I'll be able to share in a moment ways that you can come to office hours that Vecina holds through Switchboard to ask more of these great questions. So there'll be further ways to follow up with us and ask questions.
Fantastic, because there's so much going on here in terms of the chat. So I think that we can just do, let's do one more question. And we've seen a lot of questions come in about family reunification and timelines. So just we'll do this question and then we'll refer people to where they can ask further questions. How do you check the status of a family reunification application? Is there a priority system, and how long does that process take?
The status for family reunification, like the DS 4317, there's that status inquiry that we, I know somebody posted in the chat earlier, and you can just look it up. It's on the 4317 page. Like, that's the mechanism to follow up with the State Department in terms of, I think the other question was about timing. That is a large unknown. The whole system, and I think somebody asked about, how does it work? How do they get, they're literally putting people on planes. I think I understand, too, that there might have been somebody who was driven across the border into Pakistan and flown from there. Others may have had other experiences with this, but there's still U.S. flights going out of Kabul, but just not a lot of them. So, and there's way more people that want to get on those flights, and they have to do various screening for people, and everybody has to have a passport. They have all sorts of information. They want all family members, eligible family members, to travel together. So that means all family members need a passport at the same time. It needs to be valid for at least 6 months. Beyond that, like the schedule for how that happens, I don't know. And again, they get flown to another place like, say, Doha, where they then undergo further screening, whether that's a full refugee interview or an I-730 interview or some other kind of interview for immigration status in the U.S.
Great, thank you. Well, there are still so many wonderful questions coming in, so I'm going to spend the last few minutes of today's presentation letting you all know where you can go to have further questions answered and to get more information. So on this slide, we have some VACINA resources. Some of these are what Jenny had mentioned earlier on in this training about the VACINA resources on adjustment of status, affirmative asylum, and interview preparation. And also, I believe Jenny or someone else from the VACINA team is going to put a link in the chat about how you can join VACINA office hours and have some of your case-specific and other specific questions answered as well. So keep an eye out in the chat for that link as well. And of course, there are also ILSAA resources that you are able to access if you are looking for more information. Through ILSAA, there is a peer networking hub for ILSAA certified providers where providers can share practices and case strategies, ask questions, problem solve together about many of these issues that are common to all of us. There are also office hours through ILSAA held for 1 hour a week. That is an opportunity for attorneys in the ILSAA network to engage on discussions very similar to what's going on in the chat here and really share your expertise. There's information in the slide on who you can email to get more information on how to join that. And there are also ILSAA training courses, which are self-directed trainings that can help prepare you for Afghan-specific cases, including everything from substantive issues to trauma-informed cultural humility. So you can access the information on the slide here to find out more information about the ILSAA resources. And finally, there's also a legal service provider network that is made up of attorneys, accredited reps, paralegals, and other providers who are supporting eligible Afghan arrivals across the country. So if you're interested in joining ILSAA's network, there is the email address here that you can reach out to with the subject line, joining the LSP network. And when you send information to join, you'll hear back from the ILSAA team so that you can join and access more of the great resources and information that the ILSAA team has to offer. And Jenny did put in the chat the information here about how to join VACINA, how to ask technical assistant requests online through the VACINA network as well. So there's a lot of great resources for these conversations to continue. And we thank you so much for joining, and a big thank you to our expert panelists for all of the fantastic information that you shared with us today. So thank you so much to Aminat and Jenny, and thanks to everyone for being so active in the chat and sharing your experience and expertise with the community. It's been wonderful to have you all here today. Thank you.